Welcome back to Real Estate School. Today, we're going to switch things up a little bit. Instead of those tricky and sometimes very long multiple choice questions that you usually see, we're going to give you some quick true or false questions. We're bringing exam prep to you in a quick and simple format. And trust me, these questions will greatly assist you in answering those tricky questions you're going to see on your state's real estate licensing exam. So let's get started. True or false? Question number 1. The terms land, real estate, and real property are interchangeable and refer to the same thing. The answer is false. Even though the terms land, real estate, and real property are used as if they were interchangeable, they refer to different aspects of ownership rights. Question number 2. Trees, perennial shrubbery, and grasses that do not require annual cultivation are considered personal property. The answer is false. Trees, perennial shrubbery, and grasses that do not require annual cultivation are considered real estate or real property. Question number 3. A property's air rights extend upward into outer space. The answer is false. Property air rights began to be limited when air travel became common. Now, light and solar rights may limit air rights in certain areas. True or false? Question number 4. A state's power to enact legislation that preserves order, protects the public health and safety, and promotes the general welfare is called its police power. The answer is true. Police power is the state's right to enact legislation to preserve order, protect the public health, and promote the general welfare of its citizens. Generally, states pass this power down to local municipalities through legislation called enabling acts. Question number 5. A license may be terminated or canceled by the owner of the property, and a license ends on the death of either party or the sale of the affected property by the licensor. And the answer is true. A license is a personal privilege to enter the land of another for a specific purpose. It can be terminated or canceled and ends with the death of either party or with the sale of the land. Question number 6. The 3 basic ways in which a fee simple estate may be held are in severalty, in co-ownership, and in trust. The answer is true. Although the forms of ownership available are controlled by state law, a fee simple estate may be held in 3 basic ways: sole ownership, one person or entity, co-ownership with others, and in a trust. True or false? Question number 7. In a tenancy by the entirety, neither spouse can convey a half interest to a third party, and neither spouse may take court action to partition or divide the property. The answer is true. During their lives under tenancy by the entirety, the spouses can convey title only by a deed signed by both parties. Question number 8. Ownership of a cooperative interest is personal property. The answer is true. When buying a cooperative or co-op, the purchaser becomes a shareholder in the corporation by virtue of stock ownership and receives a proprietary lease to the apartment for the life of the corporation. The cooperative owner owns stock, not real estate, and stock is considered personal property. Question number 9. In the metes and bounds method, a monument may be either a natural object or an artificial marker. The answer is true. The oldest type of legal description is metes and bounds, which relies on a property's physical features to determine the boundaries and measurements of the parcel. It may include natural and artificial landmarks called monuments. True or false? Question number 10. Every township contains 36 sections of 640 acres each section. The answer is true. Townships are 6 miles apart and contain 36 square miles. They are further subdivided into 36 sections, each 1 square mile, and each containing 640 acres. Question number 11. Title is considered transferred when the deed is actually signed and acknowledged by the grantor. The answer is false. Title is considered transferred when the deed is actually delivered to the grantee by the grantor. Question number 12. Encumbrances that run with the land, such as an easement, are stated in the sale disclosure rather than the deed. The answer is false. A deed may note any encumbrances that affect title being conveyed. True or false? Question number 13. In a typical title search, the chain of title is examined, beginning with the earliest records of ownership and proceeding forward up to the present owner. The answer is false. In a typical title search, the chain of title examined beginning with the present owner and tracing backwards to the earliest records of ownership or a definite period of years, depending on state law. Number 14. A real estate sales associate is licensed to buy, sell, exchange, or lease real property for others and to charge a fee for those services. The answer is false. A real estate broker is licensed to buy, sell, exchange, or lease real property for others and to charge a fee for those services. The sales associate is licensed to do business on behalf of their broker. Question number 15. The practice of illegally setting standard prices for products or services is called a tie-in agreement. The answer is false. Price fixing is the practice of competitors setting prices for products or services. A tie-in agreement is an agreement to sell one product only if the buyer also purchases another product. True or false? Question number 16. A listing agreement is a contract for the sale of real estate. The answer is false. A listing agreement is an employment contract, not a contract for the sale of real estate. Question number 17. An agreement to be bound by most of the terms proposed in an offer constitutes acceptance. The answer is false. An agreement to be bound by all of the terms proposed in an offer is an acceptance. Question number 18. An offer or counteroffer may be revoked at any time prior to its acceptance. The answer is true. The offeror, normally the buyer, may revoke the offer at any time before notification of acceptance, but the revocation must be communicated to the offeree by the offeror, either directly or through the party's agents. True or false? Question number 19. A mortgage is classified as an involuntary lien on real estate. The answer is false. A mortgage is classified as a voluntary lien on real estate. Question number 20. An assignment of mortgage occurs when the borrower pays off the loan. This answer is false. An assignment of mortgage occurs when the lender sells the loan to an investor or to another mortgage company. Question number 21. At closing, the seller delivers marketable title to the property. The answer is true. The seller delivers the deed to the property and the buyer accepts it. True or false? Question number 22. A voluntary lien may be classified as either statutory or equitable. This answer is false. An involuntary lien may be classified as either statutory or equitable. Voluntary liens are never statutory. Question number 23. Cost and market value are the same. The answer is false. Cost and market value may be, but are not necessarily the same. When the improvements on a property are new, cost and value are likely to be equal, provided the improvements are sought in the marketplace. Think of a swimming pool. What you pay for that pool does not automatically contribute an equal amount to the value. Question number 24. In a lease agreement, the landlord is the lessee and the tenant is the lessor. This answer is false. In a lease agreement, the landlord is the lessor and the tenant is the lessee. True or false? Question number 25. The Civil Rights Act of 1968 only applies to race. This answer is false. The Civil Rights Act of 1968 applies to housing discrimination based on race, color, religion, or national origin. Thank you for watching. Please like, subscribe, and ring that bell. That way we can notify you when we have our next exam prep video uploaded. Thanks again.